Yes, Mr. Chauhan. Oh. Mr. S. Chauhan, the learned counsel appearing on behalf of the petitioner, submits that he has instructions not to press the instant petition. Taking into account above, the instant petition stands closed on withdrawal in time of the evening stands to keep. Which one? What matter is that? Oh. They just stay. Then why do you need the assistance of the court? You are the GMC and the GMD. Permission is illegal. Now they have obtained a stay order from this court. Then what do you want from this court? You are for the petitioner. You are for the respondent. So that is why. But you have the power. Stop it. Huh? Then? Hello, we'll have it on 16. Why? Who is the senior? It won't matter, madam. It doesn't look nice. No, we'll look into it and then we'll push it off. But without looking into it to mention and allowing in 2014, it doesn't look nice. You are a counsel for the petitioner. Later on, you only say that the courts are not taking up matters of old matters and are only dealing with new matters. Wouldn't you say that? No, not you. Your colleagues would be mentioning that. No, understood, but that is the feeling of the bar that look here, the old matters now. That is why we have developed this thing. This matter was very much there in the part 2 list. So from the part 2, it is now being brought in the part 1. So now you know about this matter. No. We will do one thing. Let's start it, and then if I like yesterday's matter. No, like yesterday's matter. Didn't I give you an accommodation? That electrical accident. You are not the electrical accident that you are Miss D. Ghosh? Okay. Anyways, we'll see. I won't adjourn it in a mention. Next. Which one? Item number 10 we have. Why? I don't have any matters in the list today. Everything is going to finish. Supplementary, that is why. One has already got adjourned. The other is in the process of getting adjourned. 2. Item number 10. It is at 2 p.m. Okay. You want it that we should take it before? No, 3 p.m. No, not 3 p.m. Let's see. We'll see. 2 p.m. Yes. Very much. Yesterday you were not when the matter was called. You get the record that enforcement, madam. That enforcement, you were not there. Your junior was there. Get the records for that. Yes. On 16/11. Yes. Yes. What do you want to do? 7? What is it? You suffering from? We'll see. We will see what happens. I'm not going to adjourn 2014 matter. There's no illness.
I don't know one order stay vacating.
That's okay. Yes. Who? Who has filed the IA? IA. We have it after vacation. You are the person. You have filed the IA. You want the vacating. Okay, very well. You argue. No, we'll have it after vacation. The 2021 matter, you went to that. Okay, this is the matter after vacation. Huh? They have filed it for vacating. So meaning thereby it is extended.
Okay. Number 2, coordination.
Taking into the inconvenience expressed by the learned counsel for the parties, matter sent adjourned to be listed after the deliberations. Yes, Mr. Dhawar. No, admission. Huh?
Switch shop on by owned by the petitioner.
Oh, switch shop. You are having a switch shop.
Yes.
Where? Huh? And they have closed it down.
Yes,
You have
they have changed it.
and now
Now it's that's it.
why?
But that-
Additional Deputy Commissioner who is representing? Mr. Sharma, you are there? Additional Deputy Commissioner. Why have you sealed it? Why have you sealed it? Where is the order of sealing? 53. 63. With reference to, I am enclosing here with the complaint petition of Ashok Kumar along with the food safety, wherein it is clearly said the switch shop under so and so do not possess any food license as per approved by so and so. Evident from above, the switch shop is without valid food license may endanger us. You don't have a license?
What happened? There was a dispute regarding the land dispute regarding the private person's father and my. So during the there is a dispute pending between the parties since long, and there was a probate case also that was probate was granted by the son of the. But see, during the pendency of this civil litigation, my license, trade license, as well as the food license was not being given.
You had the food license and you have applied for that.
Yes, sir.
And that wouldn't that come within the ambit of that judgment of Justice India Banerjee? Remember? Dilip dead or something. Remember? Dilip dead. That's a case of a trade license on account of disputes, electricity or something, account of some disputes between the parties. The authorities cannot, on the basis of those civil disputes, cannot withhold this. But as of now, without an FSS license, you cannot.
I have stopped commercial.
You cannot.
Yes,
So have you asked for that relief?
yes, sir.
Where is it? Writ of mandamus directing the area to renew the trade license, directing the respondent number 4 and 5 in the sub-premises area to return the seized furniture.
See the utensils of the shop.
Now, why are you not asking about the FSS license?
But I may not run anymore this shop. Or if I run, then I will apply for that is a different thing. But before that, I was
No. You see, the additional deputy commissioner sealing the shop on account of a sweet shop being run without a FSS license, there cannot be any quarrel that he's right.
No, but we cannot.
Why?
Under this Act of FSS Act,
Hmm.
we cannot.
Why?
Under section 53.
FSS.
Put 50 and standard there. Earlier, we put Section Act.
This one?
Put safety and standard act 2006.
Yes, section
Section
53.
60.
63. Yes.
Any person or whose business operator except the person exempted from licensing under substitution of 31 of the Act, himself or by any person on his behalf is required to obtain license, manufacture, sell, store, distribute, or import any article of food without license can be punishable with imprisonment for a term which may extend to 6 months and also with a fine which may extend to 5 lakh rupees.
No, this is a penalty provision.
Yes,
Now, if you don't have a license, then what happens?
that took by the.
This is only a punishment that you may be sent to 6 months and also for 5 lakhs. Now, what is the consequence of not having a license? Let's see. Or is it something that you cannot do it without a license? Where is it? Where is the provision? Duties and functions of the food authority.
Provision 31.
Section 31, section prohibition. If any food business operator is convicted of an offence under Iman and the code by which so and so, this is the prohibition, improvement articles, so and so, 31, right? No person shall commence or carry on any food business except without a license.
I had a license.
So you don't have a license. Having the act presuppose. At that point of time, did you have it?
On the, at the time of release. The seal was not done for by the food safety officer or any officer authorized under section 89 of this act. It was done by the municipal authority along with the not by any authorities under section 29 that's prescribed under. Your lordship, sorry.
The food of the human shall be responsible for them. So the enforcement can only be done under section 29 by only those food authority and the state food safety authorities shall be responsible for the enforcement.
Yes.
And you are saying that the additional deputy commissioner had no business.
For silly. I could have given a notice. There are some deviations.
So if a person is running a sweet shop without a license, which is otherwise prohibited, and you cannot run a license, sweet shop without a license, then the ADC or the deputy commissioner should close their eyes.
No matter, they have.
And are they not responsible to take note of the safety of the people in the locality?
I have closed my commercial operation from 6/4/2019. That is notice is dated.
So you give an undertaking,
Yes,
you won't run.
I own the.
Okay.
I own the document I did up to page 50. I think the reason is different.
Page?
Page 50 of the executive.
Yes.
Section 7.
Yes.
This is a letter issued by the Deputy Commissioner to the Executive Officer Municipal Board.
Hmm.
With reference to above, I am directly inform you that one Mr. Bansilal Gupta so and so has submitted an allegation received by the Executive Minister
The matter was referred to your office by office letter number so and so, that is so and so, but till this day action has been taken in this draft. The matter was then inquired into and observed the following. The land in question bearing municipal holding number so and so is found recorded in the name of Bansilal Gupta. Sri Subha Gupta and Sri so and so who are presently running this picture do not possess, could not show any proof of trade license from Dhubri Municipal Board as required under the Assam Municipal Act. Moreover, the above complaining could not show valid food license as required under the Prevention of Food Allergens. Now, 4 and 5 is important. It has also been observed that the building in which this food shop is located is unsafe, as informed by the PWD by data number so and so. Instructions are found to have been issued from the disaster management branch, visit of it to be so and so, that is so and so, but no action is found to have been taken in this regard. Page 49, this is the notice issued to the petitioner. On the executive.
And he has filed an appeal,
Yes,
Deputy Commissioner.
page 49, Lordship, and page 49. In any. The complaint.
Who are you? You are the owner of the building.
Yes, my predecessor. And here the.
No, you are Bansilal.
No, Bansilal is my uncle. He is owner of the adjacent building. That clarification earlier is full. What I did is 26/23. Asked to clarify, and I have filed an additional application. In Lordship will find there are two different buildings. Page 119 running page. Bansilal is my uncle, not my father.
But that is not the reason, Mr. Sharma.
Okay.
That is not the reason for sealing. The reason for sealing is not for other purpose. The reason is for sealing is without a FSS license.
In addition to that, your officer kindly come to page 49.
No. Why should I look into that? That is not the order which is being challenged. If you are passing this order and sealing it, the sealing is done on some other reason. And that too after at page 62, page 61, page 62. Page 62, the feasibility report has been given. The building is strong enough to maintain for another 30 years. So your reason is different. It seems both of you have a.
Page 63.
Yes.
Yeah, the reason is shown that because of the.
FSS.
Got it.
Yes, he cannot run it. That's a different thing.
Got it.
If he doesn't have a license. But the fact that if he doesn't have a license, do you have the authority to seal it? Are you an authority under section 29? Who is an authority under the FSS? In the districts? You have a food safety officer. Food safety officer who appears? You appear? Yes, Mr. B. Gogoi, you have food safety. Okay. Now, here you see, I think the food safety officer comes under you. So you can seal, you can enforce that and not the ADC has no business.
Regarding this, no, right?
Regarding when during the participation of a particular material, he may be present, but there will have to be a.
You are hereby directed to take stringent action regarding the seal of unauthorized soap for the welfare of the society. He has no business out there. You have made the health department the party. No. There you could create the problem.
By that, Lordship will find please selecting an RTI reply, even by the food safety officer. RTI was.
Yes. If any person of India himself or India who is required to have a license in shall be punishable with imprisonment for a term which may be extended. On the record of the register, so and so. Iman, it is in the name of Subhas Gupta is not found. But on the record of the register of license as per the provisions of the Federal, it is found in the name of Subhas Gupta and so and so. Okay. We set aside this order. However, give the liberty to food safety, and he shall not, directing him not to operate his shop without the license.
But license part is not the food safety part. It is the deputy commissioner who will give the license.
No, how do you enforce? No. Who is going to enforce? The enforcement is by you. So a person who has no license cannot operate. A person who has no FSS license cannot operate. That is the mandate of Section 31. And if there is a violation, he is punishable. He may go to prison. 5 lakhs is the amount fine and all. That is another aspect. But the power to enforce that is only upon the food safety officer. So I give the liberty to the food safety officer to take whatever it is required. But this sealing has to go. You have no business.
But in this letter, it is mentioned that allow me the letter of food safety to see. So some indication is there.
In the second line, page 63.
Yes, where?
Page 63, second
I am
line.
recording you a copy of the complaint petition, so along with the letter of the food safety.
Understood. But who is going to enforce as per Section 29? Let the food safety officer, I give the liberty to the food safety officer to take it. To take it forward, you have the liberty. But this order, you are only challenging this.
This order as well as sealing.
Sealing who has done?
Sealing has been done
By this order only. So this order only, the sealing has happened.
And to
Huh?
But I think 2019, whether this building has been collapsed or building has been collapsed, then it is infrastructure. Guripur Development Authority has issued notice earlier to me, I am the owner. He has occupied the building. Guripur Development Authority has issued notice to demolish the building within 10 days. Otherwise, they will demolish the building at their cost. Thereafter, also, the deputy commissioner has verified the building through the PWD department, building department. Building department has given a report. Photographs is there.
Why is the Gauripur Municipal Board having anything?
Authority is under Guripur Development Authority. As per Disaster Management Act, they have verified all the building of.
No, here we don't have the Gauripur Municipal Board.
They have not made party of it.
It's Dhupri Municipal Board. You come under Dhupri?
Yes, sir.
Who has issued the trade license earlier?
No. Guripur Development Authority control every permission for building construction and everything. Guripur Development Authority and that Guripur Development Authority is there.
Who are you? Who are you?
I am the president.
Fantastic. That is the reason why. Your dispute with him, you tackle it out in the civil court which is going on. Why are you involving these people out there?
No, I am not working.
We are only concerned with this thing.
The building is no more there.
Huh?
Building is no more there.
Building is totally collapsed. We are not getting no building. As per necessarily it is collapsed. I am the photographer. Building is already collapsed. By the
Sure.
which has been filed by the.
We have filed an affidavit
Yes, madam.
with the building collapse.
Connecting the pictures. From your photo, one building is supposed to be doing.
Page
121 is the photo. Running please.
121. Which one? Page 121. The one which has which one?
It's not left side. So see, on 5, the 2nd of May 2019.
Which one?
This is my proposal.
And what are these pictures for?
These pictures lodged on page 57 of the repetition of condition.
Huh?
Page 57 of the repetition.
Yes.
There is a photograph released by neighbors.
This is a landowner is Bansilal. This is yours.
They have fixed the building, also, page 57. They have an X. This is the report, status report given by the experienced engineer PWD on superficial observation.
What is the next building by your side?
Next building, our building. This, with glass and.
Yes. It is their building. And these photographs doesn't show your building?
Yes, because I have taken the photograph of this building. They have an X.
No. Why haven't you? Yes. This building in this photograph, still the building is there. We are concerned with this one only, ground floor.
So if this building from upper floor is school up.
How?
House is school up.
How did it collapse? Huh? Natural.
Because it was Muripur Development Authority long back given in notice.
No, he is running his shop where in the first floor or the ground floor. So ground floor is still there in these photographs.
Form portion is intact. Upper portion has collapsed. You can find one or two. You can actually report from the deputy commissioner.
Absolutely no. This is a case which needs to finish today. The whole matter. We will set aside this ADC thing, giving the liberty to all these things. Now, as regards your trade license, the authority shall take note of it if you are entitled to as per law, without going into the question of dispute between the parties. And if there is no building, no person. But this order has to go, 63 has.
Because the wrong putting of the section.
What?
They have put the wrong section. Because National Disaster Management Authority has issued a notice thereafter. See, I think the
But you have not challenged that order. Huh? You have not challenged this communication at 63.
Thereafter, this.
You have not challenged this document.
I have for the Manjama to remove the seat put by the respondent number 485 on 2nd of May. That is page 66.
How do we know?
66, brother. Can I
In reference to the application now dated so and so.
17? That is the.
Show me the original. This can't be read at all. Page 65. What is this?
69 is the serial list.
In reference to the application, it is not at all understandable. The executive officer, circle officer has come to the spot and seized the following utensils in front of the sweet shop owner. So and so.
64 is the type.
So you want only this to be removed?
But ceiling
Sealing of what?
of the shop.
No, they have only seating. Where is the sealing?
By the page 66. Reference?
But this also, have you challenged it?
Yes, sir.
Where? We have not challenged this communication. Chalo. No. The instant repetition has been filed, is filed by the petitioner seeking the following directions, seeking the reliefs as reproduced hereunder, ABCD. Ekita koriba, huh? Page 31 and 32, ABCD. Next. From a perusal of the materials on record, it reveals that the petitioner claims to be the owner of a sweet shop with MS Sarda on the ground floor of a building covered by Dhubri Municipal Holding number 05/267 old under ward number 5 of Dhubri Municipal Board of Dhubri Municipal Ward number 5 of Dhubri Municipality, situated at UNC Road, Dhubri Town. It has been claimed by the petitioner that he had been running the shop since the year 1981 with a valid trade license till the same was sealed by the respondent number 4 and 5 on 2/5/2019 and seized the furniture and utensils of the petitioner. It is also the case of the petitioner that the petitioner had a valid trade license issued by the Dhubri Municipal Board, as well as also the FSS, the Food
Adaptation Act 1960.
huh?
Food Adaptation Act.
and also a license under the Prevention of Food Adulteration Act 1954. However, it is also an admitted fact that the petitioner did not have a license to operate the shop in terms with the provisions of the Food Safety and Standard Act 2006. A further perusal of the pleadings in the repetition shows that there has been certain disputes which are civil in nature between the petitioner and the private respondent number 7, whom Mr. S.K. Goswami, the learned counsel, represents. The record further reveals that there has been various complaints being lodged made by the private respondent before the authorities concerned, and there has been certain orders passed by the respondent authorities on the basis thereof. Be that as it may, this court would limit itself to the adjudication as regards the challenge which have been made in the instant proceedings. On 14/3/2019, the executive officer of the Dhubri Municipal Board had issued an order to the petitioner, stating inter alia that the petitioner was running a sweet shop in the name of Bansilal Gupta, bearing municipal holding number 05/267, bracket new, oblique P, old holding number 5/2008, /2028, without valid trade license from the Dhubri Municipal Board as required under the Assam Municipal Act 1956, and also the food license as required under the Prevention of Food Adulteration Act 1954. It was also mentioned that the building in which the shop was located is unsafe, as informed by the Executive Engineer PWD, bracket building Dhubri. It was further observed that the Dhubri Gauripur Development Authority had instructed demolition of the said building by the letter dated 1/7/2010. Under such circumstances, the petitioner was directed to stop commercial operation in the said building and communicate the same to the office. It is also relevant that prior to the said communication dated 14th of March 2019, the additional Deputy Commissioner Dhubri had also issued. It is also relevant to mention that the said communication dated 14/3/2019 was issued on the basis of a communication issued by the additional Deputy Commissioner Dhubri on 13/3/2019, whereby the additional Deputy Commissioner Dhubri had, on the basis of a complaint filed by the private respondent, directed the Executive Officer Municipal Board Dhubri to take immediate stringent action against the shop of the petitioner as per the Assam Panchayat Act 1956. The petitioner being aggrieved by the communication dated 14/3/2019 issued by the Executive Officer Dhubri Municipal Board, preferred an appeal before the Deputy Commissioner Dhubri on 26/3/2019, stating inter alia that the shop, stating inter alia that the Executive Officer Dhubri Municipal Board had wrongly mentioned that the shop belonged to Bansilal Gupta, whereas civil disputes were pending before the court of the Municip number 1 Dhubri regarding the ownership of the said building in title suit number 46/2014. It was also mentioned that in the said suit, there is also an injunction operating dated 14/9/2017, whereby the respondent, private respondent number 7, was restrained from transferring the land and restrained and also dispossessing the petitioner from the land and the building till the disposal of the suit. Apart from the above, it was also mentioned that the petitioner had a valid trade license, but upon its expiry, the said trade license has been placed for renewal. Upon its expiry, the said applications have been duly filed for renewal of the said trade license, but on account of the civil disputes, the said trade license have not been renewed by the Dhubri Municipal Board. What happened here in the appeal?
Nothing.
It is the further case of the petitioner that although the said appeal was filed, no steps were taken by the office of the deputy, by the respondent. Nothing was, no steps was taken by the respondent number 2 in the said appeal. Although the said respondent number 2 was under a statutory obligation to do so. It has been further mentioned that the petitioner had also submitted a communication on 1/4/2019 to the Executive Officer, Dhubri Municipal Board, clarifying and stating his stand on the issue. The petitioner had also enclosed a feasibility report issued by a firm in the name and style of Brahmaputra Concrete Design, stating inter alia that the building on which the petitioner's switch shop was located had a longevity of a minimum 30 years if no natural calamities occurred. Be that as it may, in spite of such steps being taken, the Additional Deputy Commissioner Dhubri issued a communication to the Executive Officer Municipal Board Dhubri as well as the Circle Officer Dhubri, stating inter alia Dhubri on 17/4/2019, stating inter alia that a communication was received from the respondent number 7, along with a letter of the Food Safety Officer Dhubri, wherein it was clearly stated that the switch shop situated at UNC Road, Ward number 5, Dhubri, did not possess any valid food license as approved under the FSS Act 2006. It was also mentioned that the switch shop was running without a valid food license may endanger human lives and thereby may cause serious ill health issues. Under such circumstances, the additional Deputy Commissioner Dhubri directed the said officials, that is the respondent number 4 and 5, herein to take stringent actions regarding the sealing of the unauthorized switch shop for the better welfare of the society. Pursuant thereto, on 2/5/2019, the respondent number 4 and 5 sealed the switch shop of the petitioner and further seized the utensils as well as the various articles lying within the switch shop of the petitioner. The petitioner, therefore, being aggrieved, has approached this court under Article 226 of the Constitution, seeking the reliefs as already above quoted. This court, by an order dated (23/8/2021), issued notice and further directed that the status quo will be maintained in respect to the structures which is the subject matter of the writ petition. No interim order extra. However, pursuant thereto, when the matter was listed on 31/5/2000, when the matter was again listed, was next listed on 31/5/2023, the said interim order, however, was not extended. The record further reveals that the respondent number 7 had filed an affidavit in opposition. Yes, Mr. Goswami, why are you aggrieved?
Only thing is, going to development of Sophia,
No, forget about Goripur Railway. I am asking, how are you affected?
I think it's only on the ground that building,
Because it is at your complaint, everything was done. Why?
because the building was occupied them, that's what holding up. Usually, Goripur development is directed into police revenue changes. I took up the police because they occupied them. Here after also, building was like, here is the condition. If anything happens, I will be personally responsible. That is why I have made the complaint. Because I could not do anything, because he is occupied it.
So you want that he vacate?
He has not taken it.
No, you want he should vacate.
No. I have taken permission for constructing the building after issuing notice that a Goripur developer for demolished the building 2010.
So you have taken a permission to construct on the said building by demolishing the earlier building.
Goripur development authority in 2010. Before this case or before this action has been taken in 2010, I have been directed to demolish the building. As part of the inspection made,
Why? Show me that.
but you will find this here is 18 of that.
Yes. I am to inform you that you have, have been stopped commercial activity at the commercial release situated at Iman as the same has been assessed as unsafe within 3 days and to demolish the same building within 15 days from the date of receipt. But till date, we have not received any action taken by you.
Still nothing changed.
This is being given by the chairman.
But the chairman told you development.
Okay, then what happened?
They also, I have taken permission for construction of the building and where to demolish the building.
Where is the permission?
So, I think here is 26.
Yes. When was the permission given?
Permission wait long time,
When?
2012.
So immediately after that demolition thing, you got this permission.
No, in 2019.
This permission was granted when?
Demolition was there.
Where was demolition? Now I know about the demolition, but where is the permission? When was it granted? Where is it?
Last, page 26, last question. Page is there, that's it.
2012. Now,
There was 2019.
Hmm?
This petition regarding the activities regarding demolition, everything sealed and returning to the land. Hereafter, I could not construct.
now you don't want to construct.
No, I want to construct a building. They have already.
When did you get the interim order not to vacate 2017,
17.
not to dispossess?
With earlier, yes, I stopped.
The respondent number 7 has filed an affidavit in opposition denying the contents of the writ petition and also supporting the action of the respondent authorities in sealing the building as well as seizing the various articles lying inside the said building. It is further relevant to take note of that on 1/7/2010, the father of the petitioner of the respondent number 7 is dead. One Bansilal Gupta, since deceased, was directed by the chairman, Dhubri Gauripur Development Authority, to demolish the building within 7 days from the date of receipt of the said letter. And a copy of the same was forwarded to the Deputy Commissioner, Chairman, Disaster Management Cell, Dhubri. It is not known what happened thereafter as to why the building was not demolished. But it is the stand of the respondent number 7 that the building could not be demolished as the petitioner herein was in occupation. Subsequent thereto, it is also seen from the said affidavit filed by the respondent number 7 that on 3/1/2012, the respondent number 7, a permission was granted by the By whom? By the Gauripur Development Authority. To whom? Huh? To the father of to late Bansilal Gupta for construction of a ground plus 2-storied building on the same plot of land, wherein the shop of the petitioner was situated. He says, Mr. Dhar, why are you trying to spoil your case? Don't spoil your own case. However, in spite of the building permission, so granted to the late Bansilal Gupta, as well as also the direction to late Bansilal Gupta to demolish the existing building, the respondent, the late Bansilal Gupta, as well as the respondent number 7 herein, could not take effective steps. The reason must have been the suit which was filed by whom? By the reason must have been the suit filed by the petitioner before the court of the Munsif number 1 Dhubri, which was registered and numbered as title suit number 46/2014, whereby the petitioner sought for right title and interest, is it? Huh? For right title and interest over the land on which the petitioner's shop is situated. Mr. Goswami, there is a mention in your affidavit about some CRPIO. At page 3. There's some CRPIO 108/2018. Yes, what is that? That must have been against the injunction order.
They have stated that CRPIO was pending before the High Court, but that was not pending, that was already disposed.
What is that CRPIO against that order passed by the appellate order?
Against the injunction order, they have preferred CRP before the High Court. If it was preferred, if it was that CRP was disposed. If the CRP was pending there.
That has no relevance, but that order still remains, not to dispossess.
Yes, sir.
That order remains.
I do not know because they have preferred.
You cannot say you don't know. That is a part of the writ petition. How can you say that you didn't know? Or did I know from the air that they have filed a suit and got an injunction, and initially no injunction, then in the appellate court they have got an injunction. It is matter of records. Then what? No. Whether the injunction which was given by the first appellate court is still operating. I'm asking you whether the appellate court's order is operating. That is what I am asking. Here, what has happened? Kindly see. Miscase number arising for grant of which was rejected by the learned Munsif, but an appeal being misappeal number filed 9/2015 was filed before the court of the civil judge Dhubri, allowing the appeal on 14/9 to that, thereby restraining Bansilal Gupta from transferring the land and restraining the Bansilal Gupta along with his 5 sons, namely Ashok Kumar Gupta and others, from dispossessing the land and building till the disposal of the main suit. Whether that order still remains. Mr. Dhar, Mr. Dhar, it's a very sad thing. The preparation has been below par. Because that order has a lot of relevance in the instant dispute. So the best option is what to do when you have an injunction order. You involve the FSS. I still remember this particular shop. There used to be in Juro Tiniali. On this, now you have this big building, the construction on the left-hand side, just while you cross and go towards Hatigo Sariali. On the left-hand side, there used to be a sweet shop. So that shop, he got an injunction. Once he got an injunction, you can't. So the best way is what? Involve the GMC. And now you have that big building. Very poor performance, Mr. Dhar. Well, what happened there?
It is regarding the other suit. This is regarding the CRP arising out of the residential property. Which is after the-
No, I am asking, what about this order which has happened on Miss Appeal number 9/2015? Is this suit in respect to this land?
No matter the suit is still pending.
Should I speak in any other language? I'm asking you a very simple question. Kindly come to page 52. Come to 5. Have you read that? Or is it, I am drawing the attention to you for the first time?
The intention was, he was discussing 9 of 2015 was paper. And
Mr. Dhar, I have read it. I have pointed it out to you. Injunction which you sought in that suit was rejected. And thereupon on appeal, you got that. That is what I have already noted it down. But what happened thereafter?
injunction is still there. Injunction is still there.
Where? And how does the CRPIO come into the scene?
CRPIO is from the title suit 47 of 89.
There is another one.
Another
Where, how do I know?
paragraph 3
Oh,
paragraph 3 of the list. The overall pending litigation regarding residential property and this commercial property. The LPI was disposed of in project 16/8/2008.
so this order still remains. Sure. Last time, legally.
Why the petitioners sought for right title and interest over the land on which the petitioner intends to improve.
Over various lands. The petitioner, along with
Petitioner, sir.
where is your suit? You have the copy? Do you have the copy of the claim? Up?
The second,
I'm concerned with only the second. లేదు.
About the various lands the petitioner along with the reason it must have been the suit filed by the petitioner before the court of the ministry. Number one.
The reason that must have been the suit filed by the petitioner along with others against the father of the respondent number 7 and his sons, including the respondent number 7, wherein amongst various other properties, the suit the petitioner's switch shop, the property which is the petitioner's switch shop was also the subject matter. And there was an injunction operating by virtue of the order dated 14/9/2017 in Miss Appeal number 9 of the 2015. In the same affidavit which has been filed by the petitioner and by the respondent number 7, it is also seen from the records that the petitioner had also filed an additional affidavit in pursuance to the order passed by this court on 26/6/2023. To the same affidavit, certain photographs of the buildings belonging to the private respondent, number 7, as well as the petitioner, were enclosed as Annexure 25 Poly. I've heard the learned counsels for the parties and have perused the materials on the court. No, this court have duly perused the materials on record and would like to, and first, The contentions so made by the learned counsels for the parties are noted as hereinunder. Mr. Athor, the learned counsel appearing on behalf of the petitioner, submits that from the materials on record, it would be seen that the building wherein the sweet shop of the petitioner is located has been certified by an authorized certified by what is have been certified by have been certified to be a building having a longevity of a minimum 30 years if no natural calamities occur. The learned counsel submitted that the respondent authorities have taken all these steps which have been impugned in the incident petition in order to frustrate the suit wherein the petitioner has obtained an injunction that the petitioner cannot be evicted by the private respondent or his predecessor till the disposal of the said suit. The learned counsel further submits that though it is true that the petitioner does not have an FSS license, does not have a license under the Food Safety and Standards Act 2006, but the petitioner had a license under the Prevention of Food Adulteration Act 1954, which was submitted for renewal, which is yet to be renewed. The petitioner the learned counsel further submits that the trade license also, which ought to have been renewed, have not been renewed on account of the civil dispute between the petitioner and the respondent number 7. And as such, thereupon, the learned counsel further submits that the Food Safety and Standards Act 2006 is a special act which categorically stipulates that the enforcement stipulates that Section 29 of the Act of the said Act, Act of 2006, that stipulates that Section 29 of the said Act of 2006 that the food authority and the state food authorities, safety authorities, shall only be responsible for enforcement of the Act. The learned counsel submits that the additional deputy commissioner, therefore, could not have directed to the respondent number 4 and 5 by the communication dated 17/4/2019 to seal the shop of the petitioner. For not having a license under the Act of 2006. He further submitted that the further action on the part of the respondent number 4 and 5 on 2/5/2019 was also unauthorized, as they are also not authorized authorities in terms with section 29 of the Act of 2016. Anything else? I'm coming back. Mr. S.P. Goswami, the learned counsel appearing on behalf of the respondent number 7, submitted. That the land as well as the building wherein the petitioner claims, wherein the sweet shop was run by the petitioner, belongs to the respondent, belongs to the father of the respondent number 7. And after his death,
He's legal here. All legal heirs are not made by 41.
and after his death,
It's all-
it has devolved upon the legal heirs of late Bansilal Gupta. There was a direction issued by the chairman, Dhubri Gauripur Development Authority, to demolish the said building by the communication dated 1/7/2010. However, on account of the petitioner not vacating the switch shop, the said directions could not be complied with. Further to that, the learned counsel submitted that as the petitioner did not have the license as required under the Act of 2006, the respondent authorities were within their jurisdiction to close down, to seal the said switch shop and seize the materials. Further to that, the learned counsel also submitted that as far back as of 3/1/2012, permission had also been was also given to the father of the respondent number 7 for construction of a building which could not be done in view of the illegally run switch shop by the petitioner. Anything else? Mr. H. Sharma, appearing on behalf of the respondent number 1, 2, 3, and 4, submitted that as the petitioner was running the switch shop without a license as mandated under the Act of 2006, the respondent authorities, for preserving the respondent authorities in order to take into account, by taking into account the safety of the people, were justified in taking the action on 2/5/2019 for sealing the said building, as well as seizing the utensils and other goods and other material, other furnitures inside the said switch shop. The learned counsel, Mr. H. Sharma, further submits that from the communication dated 13/9/2019 issued by the respondent number 4, respondent number 3 to the respondent number 5, it would also show that the said building was not safe. And accordingly, directions were also issued to the respondent number 5 to take appropriate action in the matter. The learned counsel submits that although action was taken on 14/3/2019 by directing the petitioner to stop his business, but the petitioner still continued to do his business, and under such circumstances, the respondent authorities were justified in resorting to the actions as was done on 2/5/2019. You are appearing for? Yes, what is your stand? You have done as per the directions of the Deputy Commissioner. Mister, your name? So and so, appearing on behalf of the respondent number 5, submits that the actions have been taken by the executive officer, Dhubri Municipal Board, on the basis of the directions of the additional Deputy Commissioner on 13/3/2019, as well as 17/4/2019. I've heard the learned counsels for the parties and peruse the materials on record. The first question which arises for consideration is as to whether the respondent number 3 4 and 5 had the authority to take steps under the Act of 2016 for ascertaining the said aspect, the said question, for adjudicating the said question. This court finds it relevant to take note of Section 29 of the Act of 2016, and more particularly Section 29 of the Act of 2016, 6, which stipulates who are the authorities responsible for enforcement of the Act of 2006. A perusal of the said section reveals that it is only the Food Authority and the State Food Safety Authorities who shall be responsible for the enforcement of the Act of 2006. At this stage, this court finds it relevant to take note of that a specific query was made to the learned counsel appearing on behalf of the respondent number 3 and 4 as to whether any authority has been conferred upon the additional deputy commissioner or even the circle officer to resort to take actions in terms with the Act of 2006. Full stop. The Learned Counsel, Mr. H. Sharma, with due fairness, submits that such action has to be resorted to by that for the purpose of enforcement of the Act of 2006, it is the food authority and the state food safety authorities who are responsible for the enforcement of the Act. He further states that it is the food safety officer.
But from the notice, it's the additional deputy commissioner, there is no such designation there.
And who is he? Food safety officer Dhubri. Food safety officer Dhubri, who would be authorized in terms with the Instant Act to take such actions under the Act of 2006. The said query, as well as a perusal of Section 29 of the Act of 2006, therefore makes it clear that the respondent number 3, 4, as well as 5 had no authority to take any actions for violation of the provisions of the Act of 2006. It would only be the food safety officer Dhubri, who is an officer authorized by the Health and Family Welfare Department, Health and Family Department of the Government of Assam, who would be authorized to take actions in terms with the Act of 2006. In that view of the matter, the impugned actions on the part of the respondent authorities, more particularly the respondent number 3, 4, and 5, in issuance of the communication dated 17/4/2009 and the subsequent sealing of the office of the sweet shop, as well as seizing the utensils and furnitures lying within it, are completely unauthorized. For which the same are set aside and quashed. Accordingly, this court therefore directs the respondent number 3, 4, and 5 to take appropriate steps for desealing the building of the petitioner, as well as returning the utensils and furnitures which were seized on 2/5/2019 to the petitioner upon service of a certified copy of the instant order to the respondent number 3. Next. This court further, be that as it may, this court cannot also be unmindful of the fact that the petitioner does not possess a food license as is required under Section 31 of the Act of 2006. It is therefore observed and directed that till the petitioner does not acquire a food license in terms with Section 31 of the Act of 2006, the petitioner shall not carry out commence any food business in the said sweet shop. This court further finds it relevant to take note of the submission of the learned counsel appearing on behalf of the petitioner to the effect that for the purpose of trade license, that the petitioner had a trade license which had expired and a renewal application had been filed, but the respondent authorities, on account of the civil dispute, have not renewed the trade license. At this stage, this court finds it relevant to refer to a judgment of the Supreme Court in the case of Dilip Dead versus Dilip Dead through LRs versus Satish and others, reported in 2022 SCC Online SC 810, wherein 810. The same judgment, though rendered in the case where an electricity connection was not given, on the ground of failure / refusal of the landlord to issue no objection certificate. The Supreme Court directed the Supreme Court observed that electricity cannot be declined to a tenant on the ground of failure / refusal of the landlord to issue no objection certificate. Similarly, this court had also, in the case of judgment Mr. P. Nayak was there, GMC. Similarly, this court had also, in the case of so-and-so versus so-and-so, dated in this court had also by an order dated so-and-so, in the case of so-and-so versus so-and-so, had also observed that a trade license cannot be withheld on the ground of dispute between landlord and tenant. Applying the same principles, this court is of the view that a trade license this court is of the view that the trade license, being a license issued for the purpose of levying professional taxes, cannot be withheld merely on the ground that there is a civil dispute pending between the parties. The license, the trade license, has to be issued on the basis of the extant laws applicable and not on the basis of a civil dispute pending. Under such circumstances, this court directs the respondent authorities, and more particularly the respondent number 5, to consider the application for renewal of the trade license by the petitioner if the petitioner is otherwise entitled to, as per the provisions of the Assam Municipal Act 1956, Push. Next. This court also is of the view that the instant judgment so delivered shall not affect the rights of the respondent authorities, more particularly the respondent number 5, to take appropriate action if permissible under law. As regards the building, as regards the permissible under law. As regards the on the basis of this, on the basis as regards as to whether on the basis whether gives the liberty.
This court also is of the view
That the instant judgment shall not preclude the rights of the respondent number 5 to resort to such actions if permissible under law, if it consider that the safety of the building, if it consider that the building is unsafe to human habitation and unsafe. However, in doing so, the petitioner has to be given proper notice. With the above, the instant proceedings. And again, this court, however, finds it relevant to observe that the instant judgment shall not preclude the rights of the respondent number 5 and respondent number 6 to take an independent decision on the basis as to whether the building is safe. If any action, however, by giving the petitioner a due opportunity of hearing. You are asking for renewal. How can I help you? You then say that trade license you are not, but you then I won't mention about all these things. You want that? No, if you don't want the renewal of that trade license, the trade license is something else. Now, you may not like, if you don't want, then it is that will be a different direction. But you here, the prayer is only for renewal. So renewal, I've kept it like this.
And license is not in respect of the recent building. Another building. Trade license is the next in respect of the death of regarding cancer.
Trade license, is it given on the basis of the building?
No.
The trade license is a license which is being taken only for the purpose of collection of professional fees.
Trade license was issued in respect of the holding number and holding.
Understood, but you see, they mention it out there. But what is actually a trade license? The trade license is a professional fees. You see the GMC Act 183. It categorically shows that it is a professional fees being taken for the purpose of running.
But in the license, which is added.
Although the lawyers are not issued the trade license, but you are still paying a professional fee. How do you pay the professional fee? That is a professional fee which is being taken by the GMC authorities or by the state sale tax authorities they collect. This is a professional tax. It's a professional tax which is being taken. Huh? Which one? No, that matter has already been done with by Justice Suman Sham. He has delivered a judgment, and thereupon the matter went to the division bench, which was moved by Mr. J. Roy. But they said that we are going to submit a representation. Matter ends there. So the law is now clear to the effect that it is a tax, professional tax, which is being done. Anyways, you want a liberty to that effect. Then what do I do with the renewal?
They're not given because
Do you want the renewal or what?
that question I don't have because after lapse of 3 years, more than 3 years. Then you like.
You express an urgency in the matter without a lapse. If you have no connection with him for last 3 years.
Not there.
Huh?
Utensils are also been seen, and the shop is closed for more than 3 years. Now whether you would like to do the business of food or any other business.
তাতে এটা ওপৰত লাইন লেটাৰ এই তাতে কিনি লিখিলে এটা লাইন এটা লিখি ৰাখকচোন মই কৈছো before concluding this court further finds it relevant to take note of the submission of Mr. Adhor, the learned counsel for the petitioner, that the petitioner that the directions passed herein as regards the renewal of the trade license shall not affect the petitioner, shall not prejudice the petitioner to apply for a trade license in respect of other goods. It is made clear that the directions made herein above, or made clear that the instant judgment so passed shall not affect the petitioner to apply for a trade license in respect of any other vocation.
Item number 3 for hearing.
Inspection that FR has been submitted. When you
Huh?
look at the patent and here's a, the petitioner-
FR. FR submitted. Where is it?
Number 176 dated 18/8/2017.
Before
CDM Nova.
this is a matter pertaining to what?
We sought for CPA or any other.
So you have to approach. When did you submit?
18/8/2017.
The instant petition has been filed by the petitioner seeking a direction that the Rupohi he had PS case number 310/2012 be seeking a direction that the Central Bureau of Investigation be directed to investigate the Rupohi Hat PS case number 310/2012. The learned counsel appearing on Mr. S.S. Roy, the learned counsel appearing on behalf of the government submits that in respect to Rupohi Hat PS case number 310/2012, FR, a final report being Nagaon,
PS number 176. PS FR number 176.
being FR, but FR being Rupohi Hat PS FR number 178/2000, 176/2000,
Dated 18/8/2017.
176 dated
18/8/2017.
18/8/2017 have already been submitted after completion of the investigation before the Chief Judicial Magistrate, Nagaon. Taking into account the above, this court disposes of the instant petition, granting the liberty to the petitioner to avail such remedies available against the said final report if so advised and if so advised. First, the petitioner shall also be liberty to apply before the it's so advised. With the above the instant petitions You are for CBI. Who is for CBI? And who is for the other one? You are for whom?
And for the state.
You are the respondent.
Yeah, that's. Represent the SP and the respondent officer.
Appearing for respond number?
One to five.
Huh?
1 to 5.
Respond number 1 to 5 submits in working bole. You give your name on top, it will be. नाम किधर दी थी बोल? ऊपर.
Item 4.
Report size है ना? Oh, it's a dispute between brother and sister. Huh? You are for the sister. He's for the brother. You're fighting. And the settlement was made actually for the mother. And the mother should have got it, but the mother didn't get it. Now it has been given to you, and you married and went away. In spite of that, it has been given to you. My goodness. Hmm? What? What do you say? Fantastic. We part, both of you half up the land? There's an interim order. But madam, you have a big problem. Your you should have, instead of challenging those things in the civil court, you should have challenged that yes, Mr. Roy, what do you want? Huh? See, wrongly filed a civil suit in that manner. It must have been done under 154C, which cannot be done. But if you could have made it differently, claiming that whatever may be the son has being the inheritor on the basis of a no objection like this would not have been settled. Everybody has a right over the land. No, there is no quarrel with the proposition that the mother was entitled. Mother was. The question is whether the respondent number 4 in the appeal or respondent number 5 for whom you represent is entitled in exclusion of others. That's the case.
It was a government land. There is no question of inheritance or that the legal heir cannot claim because the respondent number 5.
No, was it given to the respondent number 5 on her own application, divorce the mothers? Or was it given on the basis of the mothers on account of the no objection begun by the mother?
Respondent number 5. It is government for the settlement of the land inherited. And mother had even more.
No, was the recommendation made by the ADC? That is the basis?
Yes.
On the basis that the mother was the tenant earlier. And accordingly, the mother is entitled, but in view of the no objection given by the mother in favor of the respondent number 5, it should be given. If that is the case, it is a different story.
Mother had given no objection.
If that is the reason for settlement, it has a different connotation from apply. If it is being applied to you by you and you got it, it's a different aspect. But if the basis or the edifice of the claim of your right springs from the mother, then the question becomes different.
Originally, the land, it was a government land.
Understood. There's no quarrel. It's a government land. A government land is no quarrel with the government land aspect.
But the petitioner.
But the fact that was the land given because of the mother, or was it on independent?
Mother was the original possessor of the.
Absolutely. So that is why the recommendation was being made.
Question of inherited by the mother. The petitioner is claiming that he is one of the co-owners. Co-owners of the land, and that land was a government land. The question of co-owner or joint.
No, the petitioner claims that the right which the mother had also devolved upon the petitioner along with the respondent number 4.
When there is the government land, how it would devolve upon the sons and daughters of.
Are you saying that? That they won't? Are you saying that the person, the father, if he is in possession of a government land for 10 years or 20 years or 30 years, and the father dies, the son thereupon cannot claim that the father was there in possession and that 30 years should also be taken into account for the purpose of settlement.
Suppose lordship, there are more than one legal.
That is why.
Other legal aids do not apply for settlement. Some
So,
of them apply for the settlement.
so she,
So like government, it is the lordship under the land revenue regulation, state government is the higher authority. When the state government, lordship is pleased to consider that when the government has settled the land lordship, the highest revenue authority lordship, the board of revenue cannot entertain the appeal law.
not necessary, not necessary, but the prayer has also been made out here for a certiorari. This court can very well do it. Are you saying this court cannot?
Lordship actually,
You are not prepared.
I have lost my dream,
See,
not present. I may be.
see, madam, who took time? Why you were only trying? Eat it. Yes, taken. Mr. SP Roy, the learned counsel appearing on behalf of the respondent number 5-6 for an accommodation.
I don't consider the institution is the administrator of the settlement. Where is my fault? I whole life, almost 3 hours, I just decided.
And you don't know, your client is not there to help you out. How, what can I do? You have a copy?
At my fault. I bring.
That is both internal for both.
Okay.
So, sought for an accommodation in the matter. Your name? C. Muzumdar expresses urgency in the matter, taking into account that there is an urgency. Taking into account the above, list the matter immediately after the presentations.
Number 6.
Yes, what is your case? Calling upon the respondent shall not be issued quashing the notice dated so and so of eviction, as well as the nature of mandamus. Yes. Eviction notice.
Yes.
Where is it? Page 33, page 32. So and so both as per the direction of the Deputy Commissioner dated, you are hereby informed that this notice is to vacate the plot of land measuring so and so, which was allotted to so and so. Otherwise, you will be evicted forcefully from the said land under sections of the remand. Today on remand given under your signature. Then you gotta stay.
Yes.
Then what is your right? What right? You have been settled. No. Have you been settled that land earlier? Where?
CH29 meter.
Show me. Subject to the referral respectively to state that the government has passed an allotment for a plot of land measuring 18 lechas covered by Dag number 132. 18 lecha. Are you sure? 18 lechas covered by Dag number 132 of village Korumotoria under Beltola fixing premium at Swens. So you have been given 18 lechas. Now let us see the notice which have been issued. How much?
I paid the premium.
No. How much land is the question out here? Where Beltola, Mojar, Horumuturia, Gaud, Iman number, Dagor, Iman number, Iman. See?
I'm only going to get part of land.
Only 18 lechas. So beyond that, you can be evicted? No. Matter is simple. Yes, Mr. Talukdar. Matter is simple. Beyond that, you evicted. Now, understood, he have been allotted 18 letters. Where? Where is the other petition? Huh? No, if you have not deposited, matter over. I'm not concerned. And why are two petitioners filed? Completely different cause of action. We'll dismiss it on that ground. No, Mr. Counsel, you cannot file this type of matters like this. No, this cannot happen. Because of you, this petition is going to be dismissed. We impose a cost upon the lawyer of 50,000 because of you. Why have you filed? There are two persons having completely contrasting rights. What? So what? One person has deposited the amount, the other has not. So if you don't deposit, do you have a right? No, tell me. No, do you have the right? Isn't that the allotment orders made subject to the deposit of the premium? Then, so no right has flown upon them. We dismiss cost upon you, the lawyer who filed it, of 25,000. Regarding allotment of land, with regard to the, I have the honor to send here with the proposal for settlement of so and so. This is done by whom? This has no relevance. This has no relevance. So I'm so and so Deputy Commissioner settlement of revenue to Borguia and his wife so and so. They recommend for settlement of 18 lessons of land covered by so and so for a premium of rupees which has been fixed at rupees here per katha. So which will be Iman. The possession of the, here it says, subject to payment of the premium at the rate of 40% of the land value which is fixed at so and so. The possession of land may be handed over to the person concerned and the land records may be corrected and patta issued after realization of the premium in full. In fact, if one judgment I have delivered recently, that without patta there is no right. Where is the other person? Page? Yes. Your name means which name? Where? Page 22. Serial number 9. Yes, what is that? What is that? Where is the similar type of order in favor of the petitioner number 2? No, I'm not concerned. This is only a proposal. No, sorry, that's only a proposal. But where is as regards to petition number 2, there is an allotment. Yeah. Sorry. You vacate everything except the 18 lectures which have been allotted to you. And have you got the settlement? When did you enter into possession? You were having the possession. Okay. So that person can remain in view of Rule 16. But have you asked for issuance of the patta? Where? Directly to correct the land records. And also, Imam shall not be right to be paid the premium and correct the remaining. So, petitioner number 2, no case. And imposition of cost of 50,000 upon the lawyer for filing this petition jointly. All have different cause of action. You get relief of 18 lectures and pay, and not from your client, from your own pocket. Huh?
At that time, I was 49. At that time, I was asked why is it euro of Sharma.
Fantastic. Ask the money from Pishon.
Yes,
So then you do whatever you like. Sell his assets if you have. But then also you have paid this 50,000 from your pocket. Nothing doing. Your name?
Yeah.
Alhamdulillah. Next time I don't want to see this type of mistakes again. The instant repetition has been filed by two petitioners challenging the notice dated 3/38/2014, whereby they have been directed by the circle officer, Dispute Revenue Circle, to vacate the land measuring 18.38 R, 18.38, no, 13.38, 13.38 R, situated in dark number 132 new 35 132 old 35 new of village Korumotoria under Beltola Moza on the ground that the said land had already been allotted to the respondent number 6. The facts involved in the instant case, as could be discerned from a perusal of the pleadings, is that the petitioner number 1 had recommended is that the governor of Assam had recommended for settlement of land measuring 18 lechas covered by dag number 132 of village Korumotoria under Beltola Moza with the petitioner number 1 and his wife Srimoti Raima Begum Borbhuiya for residential purpose, subject to payment of premium at 40% of the land value, which have been fixed at rupees 3 lakhs per katha. It was also mentioned, this recommendation was communicated to the Deputy Commissioner Kamrup Metro by the Deputy Secretary to the Government of Assam Revenue Settlement Department by the communication dated 3/8/2006. It was also mentioned in the said communication that the possession of land may be handed over to the person concerned and the land records may be corrected and patta issued after realization of the premium in full. Subsequent to the said communication, the Additional Deputy Commissioner, Kamrup Metro, issued a communication to the Settlement Authority, Settlement Officer, Guwahati, forwarding the communication dated 3/8/2006 and requesting the settlement officer to make necessary correction as per the trace map of the plot of land measuring 18 lechas covered by Dag number 132 of village Horomoteria under Baltola Moza, and to give possession to the petitioner. The record further reveals that the petitioner deposited the said amount of, as mentioned in the communication dated 3/8/2006, on 10/8/2006 itself, by payment through the challan. Be it as it may, although allotment has been made, although there has been a recommendation to make settlement by the governor, it is not known as to whether the periodic patta have been issued, periodic lease has been issued in favor of the petitioner number 1. Now, coming to the case of the petitioner number 2, it is an admitted fact that there has been no recommendations, as was done in the case of the petitioner number 1, as well as there has been also no deposit of any premium, and there has been no recommendation as has been done in the case of the petitioner number 1. Understood. That is what I'm going to say. You have been given almost 1 bigha. 1 bigha. You have filed affidavit. I Okay. In the backdrop of the above, if this court takes note of the notice, the impugned notice, it reveals that the same notice pertains to an area of 13.35 R, which corresponds to 1 bigha of land. Of Dag number 132 old, 35 new, this court also takes note of the interlocutory application filed by the respondent number 6 being IA Civil 1507/2016, whereby the respondent number 6 sought for vacation of notice of some is measures 1 beta. The petitioner being agreed, petitioners jointly. And the petitioners, however, though having completely two different set of rights, have filed the instant writ petition jointly, challenging the impugned notice dated 30/8/2014. This court, by an order dated 16/9/2014, issued notice and in the interim state the eviction notice dated 30/8/2014 to the extent that the same shall not be enforced against the 18 letters of land allotted on 3/8/2006 to the petitioner number 1. However, in respect to the respondent petitioner number 2, there was no order passed in view of some interim protection granted to the petitioner number 2 in another writ proceedings. It reveals further from the records that Kishalai Vidyapith High School to whom the land was allotted, as mentioned in the impugned notice, had sought impleadment in the instant proceedings by filing an interlocutory application being IA Civil 1508/2016. This court, by an order dated 15/3/2017, impleaded the said Kishalai Vidyapith High School as the respondent number 6. It is also seen that the respondent number 6 had also filed an interlocutory application seeking vacation and modification of the order dated 16/9/2014 in the instant writ proceedings. From a perusal of the said, Miss, yes, your name? So and so, appearing on behalf of the respondent number 6, submits that the said interlocutory application be treated as the affidavit in opposition of the respondent number 6. This court has perused the said interlocutory application, wherein it is seen that on 14th of September 1994, The Deputy Secretary to the Government of Assam Revenue S Department had informed the Deputy Commissioner Kamrup Guwahati that a plot of land that the Governor of Assam had ordered for allotment of a reserved Sarkari land measuring 1 biga covered by Dag number 132 part of village Porumotoria under Beltola Moza in the name of Kishaloi, in the name of the respondent number 6, subject to the condition that the allotted land must be utilized within 3 years for specific purpose, failing which the land will be reverted to the government in the revenue department. It was also mentioned in the said communication that the possession of the land may be handed over to the concerned authority after keeping roads and drains, etc., as per the normal norms of the Guwahati Municipal Metropolitan Development Authority. Assam Guwahati Metropolitan Development Authority. And as per the latest guidelines communicated by the department's letter number RSS.833/93/PT.Roman2/6 dated 19/9/1994. Further to the, it is also relevant that to the said communication, a trace map and chita was also sent for taking necessary action. The record further reveals that the Undersecretary to the Government of Assam General Administration Department issued a communication to the Deputy Commissioner Kamrup dated is what? What is the date of this communication? Had issued a communication to the Deputy Commissioner Kamrup for handing over the possession of the 1 biga of land to the petitioner, to the respondent number 6, by removing the unauthorized encroachment. Subsequent thereto, on 14/2/1995, the settlement officer Guwahati have written to the Deputy Commissioner Kamrup that the allotted land could not be handed over in view of occupation on the allotted land of one Sri Kamini Sen Deka and 3 other persons. It further reveals that by another communication on 21/11/2000, the Deputy Secretary to the Government of Assam Revenue S Department requested the Deputy Commissioner Kamrup that as the injunction order which was passed in respect to the land have been vacated, necessary steps be taken to hand over the possession of the land to the respondent number 6 school. It is also seen that there has been various attempts being made and subsequently made, but the possession could not be handed over to the respondent number 6. However, on 17/8/2014, the additional Deputy Commissioner, Kamrup Metro, had written a communication to the circle officer, Dispur Revenue Circle. 17/8, page 21. To the circle officer, Dispur Revenue Circle, directing the said circle officer to initiate eviction process for land measuring 13.38 R covered by DAG number 132 old, 35 new of village Korumotoria under Beltola Moja, already allotted in favor of the Kishaloi Vidyapith by government letter dated 14/9/1994 as per rules and provisions from your end. It is therefore the case of the respondent number 6 that the impugned notice thereon was issued on the basis yes, Mr. Talukdar, there has been various affidavits filed in this. Yes, the Deputy Commissioner has filed. So what is the status? Now what is? Now kindly come to the affidavit filed by the Deputy Commissioner. Says that old DAG number 132 mentioned in the aforementioned case is DAG number 132 old 35 new of village Korumotoria and the Beltola Moja. In the comment section of the Chitar, it is mentioned as Rajdhani. The said land is not under the possession of the school or the applicant. As per the field mutation, a field verification report submitted by the circular is in the recorded patta of the land covered by DAG number 138 old 36 new of KP patta number 546.
That school is recorded patta there.
So is that the patta which has changed? You have issued the allotment. Now, once you have issued the allotment, have you issued the periodic patta?
But the allotment, after allotment, there has to be premium.
Premium you have paid. Handed over will be only subject to, there's no premium payment required. Is the premium required or not? No, there's no premium required. It's a grant. It's a grant. No premium required. The allotted land must be used for free.
But possibly because land would not be eligible.
Now, that I've understood. Now, his right is, as regards one is 18 litres. Now, if the land records have not been corrected, meaning thereby that what could be seen from the affidavit of the deputy commissioner, it is clear. Huh? No, school name is there in respect of some other dog. So is this the dog which have been given? This dog number 138 or 36 new of KP Patra number 546 is how much land? Have you got the land? Madam, have you got the land? Possession of any land?
Okay, allotment, land has been allotted to you. Allotment order is due,
No, your affidavits are not clear. No, there is another affidavit filed by the circle officer, again pursuant to an order passed by this court. Says at paragraph 4, it is seen that old dog number mentioned in the above mentioned case is government dog number so and so. In the comment section of the Chita, it has been mentioned as so and so. It is seen that here is a recorded pattadar of this land. They craves the leave of this court to refer and rely upon the Chita and the trace map at the time of hearing. Where is it? That is the crave leave. We'll take it up at 2. Get hold of the Chita and circle. Because you have crave leave. Else ask that person to show it out there in the virtual. Yes. What is? Last year, again.
It is also seen that there are some areas, sometimes area that is happening, better position to not be in the river to the response number 6. On 17, 14, there is no district, the national family.
So how much is the area?
Also, I think just from the record.
No, the record says,
Okay, if I take up the. Yes, ma'am.
no, that is what I've seen. This
That is the
particular,
Patta land,
no, this is a land.
Patta land.
Now, this land has come into existence from the original 132.
It's a different, right? It has come from 138
138,
and the view that is 36.
36.
So we are not concerned about that because these are Yadi land, Patta.
This is, the school is functioning from here.
Maybe one Lavanya is also to find this.
Old land.
Huh?
Adjacent to,
That doesn't,
adjacent land.
So there is you are asking for this land, this 35 core, 36 core. This is also 36.
no,
Where is
this
35?
already there.
Huh?
It's a Yadi land. Yadi land, registered in the name of one Lavanya is also to find it. As secretary of the school.
Labanya Potro Prabha Borua.
সম্পাদক so and so.
Prabha
So that is the Yadi
সম্পাদক।
land, clearly Patta land. But allotment was given in the other land.
This one, the bigger.
Bigger, bigger. And they both are here. Their land is only 18 lesser than 1 bigger.
One was lost.
No, therefore, as he has been given an allotment, you can't touch 18 lectures.
18 lesser.
But for remaining area, you can very well evict if he is in possession. And if the petitioner, if the respondent number 6 allotment of 6, 1 katha of land, 1 bigha of land, should not affect this. But that is a separate cause of action. The pity that respondent number 6 is not before this court. Why should I look into that?
But this
That is an independent cause of action. Why should this court in an interlocutory application look into those aspects? We only interfere with the notice to the extent that the petitioner should not be evicted
from his
18 lectures. Petitioner number 1. Other petitioners, you can show them. That is a separate cause of action, madam, which you have to fight with him standing on this side. Now you are both on same side, so you cannot.
Can we stop this page, 14 of their distribution? Earlier on, distribution 57.
No, you see 35, no. You see the reason why I'm saying 35 number Dag is a very big Dag. Now, the entire Dag, how much land is there is not known. Is not known. It's a government land. So the government may not disturb that, may give you some other plot of land in 35. That's all. That I'm not saying on anything. But only 18 lectures. We are only concerned as to whether he should be thrown out from this 18 lectures of land. That's all.
Land lost by the order WPC 5182. There is a mention that land that is 1 acre cut of 10 acres. Yeah.
I'm not concerned. They may occupy 10 bighas or something. His only right is of 18 lectures. If he's in occupation of more land, throw them out. Leho, kili.
1714, Direction of State Council of Metro that returned to the circle officer displayed in the circle. Directing the said circle officer to initiate election process for the land design. 13.8 are covered by tag number 132 or 35 May of this form under the economic design. Already allocated in favor of the David School, I government letter dated 14/9/94 as per the rules and provisions from guidance. It is therefore the case of the response number 6 that the impugn notice hereupon was issued on that basis.
This court have duly considered the submissions of the learned counsels for the parties. The petitioner number 1, upon his allotment, upon being recommended for allotment, by the communication dated 3/8/2006 had duly deposited the premium on 10/8/2006. It is also seen that the Deputy Commissioner, Kamrup Metro, had also written a letter to the settlement officer to that effect. The said 18 lectures of land be handed over the possession to the petitioner number 1. Under such circumstances, though the petition number 1 is yet to be issued the settlement order, but the petitioner's possession in respect of 18 lectures of land which have been allotted cannot be disturbed by issuance of a notice, by issuance of the notice dated 30/8/2014. Be that as it may, it is also relevant to take note of that while the petitioner's land, allotted land, is 18 lectures, the notice is in respect of 13.35 R, which corresponds to 1 bigha of land. 13.35 R of land, which corresponds to 1 bigha of land. So, under such circumstances, this court permits the respondent authorities to proceed with the eviction in terms with the notice dated 30/8/2014. However, it is made clear that while proceeding with the said eviction, the petitioner's possession over 18 lectures of land which have been allotted should not be this petitioner number 1's possession over 18 lectures of the land which was allotted to him should not be disturbed. It is made, this court further makes it clear that the petitioner number 2 has no right over any land in occupation, if so in occupation, and the respondent authorities would be at liberty to take such action as deemed fit, unless prohibited by any other orders passed by this court. With the above, the instant petition therefore stands disposed.
They had allotted to us and this is allotted to us and the circle of one that is the target. Now they are saying that this card number we have allotted the land is card number different than me. So they are saying it's a contradiction. So
Before parting with the record, this court further makes it clear that this court had not adjudicated the rights as regards the petitioner, the respondent number 6 entitlement to the possession over the land allotted to the respondent number 6. The respondent number 6 would be at liberty to take such resort to such action as permissible under law.
I
Yes, the 5 lakh amount, whose case was yours? Yes. What happened? 2,50,000? 2 lakhs, you happy?
As per his person, madam.
No, don't go by person. You are ready? What have you agreed to? Have you agreed to 2 lakhs?
That, I got the structure that some integration in the ability to put
I am asking you whether you are agreeable to this 2 lakhs or not.
they are agreeing.
And you are not agreeable to 2,50,000. You go to the civil court.
In fact, there is an order of this court.
Yes.
And there is other such dispute is whether there are other an attack father to take away the entire amount by somebody else father. Then there is a case father the data will be entitled to rupees 50%. That is 50%.
From whom?
From the person mother who is making attack to mother take away at the amount. So in this case, there was a state mother who make an amendment.
No, Mr. Counsel. Tell me one thing. Can this court issue a writ to him? This court can only issue a writ to these people. I can't issue a writ to him. If I can't issue a writ to him, they categorically say that we have already given the money. This is a dispute between both of you.
This what they he annexed from the care donation of which is 1,50,000. So moment he annexed that is two annexes there.
I have seen it. 1,50,000 in his name to some mandir.
Monday.
Yes.
So that is what current extra comes. So momentum that we are setting.
No, you see, if you go to the civil court, you may be entitled to the entire amount.
They are not in a position.
No, if you want to go there, that is the only thing. But if you are not, this court is not in a position to direct him. I would have otherwise taken his undertaking and then could have directed them, and else it will be a contempt if he does not pay. That is the only way I would have done it. It's a different thing that this court will write up many other things. That is a different thing, but
We can send a government employee.
who?
My money.
And you are
I'm just business steady man.
what?
I'm a business steady man. I got married to just I'm.
And what does your husband do?
He doesn't mind it.
And you? You
I'm also equal.
you also don't do. So how are you surviving?
That is the main.
Only this because of the martyr. What will happen after the 2 lakhs is over? Or 2,50,000 is over? Tell me.
That is my prayer. If you don't, I leave it to you.
Don't leave it to me. Nothing to leave it to me.
It will be difficult when a school approaches it. It will take some more time. They are not in a position when the 250 they are agree. In fact, that person was also agreed to that. Now he has changed the concept. Next, for the moment of that is also not believable.
And both of you, and you only on 2 lakhs, no? No more further opportunity to both of you. Yes, Mr. Hendrik. How did you pay it to him? To the respond number 4? What document? It has to be it is paid to a next of kin. And if the next of the kin certificate which have been obtained false, you do one thing, make an inquiry, you submit your report, you file an affidavit as to on what basis you paid, because this certificate this affidavit which have been filed with the respondent number 1 is hopeless. You say that as one beneficiary has been given, because the brother will come in the second class heir. The first class heir would be the daughter. Then if it is based on a certificate which is false, then obviously you can take criminal proceedings against him. Okay. This court, upon hearing the matter, and also upon perusal of the materials of the court, finds that it is an admitted fact that the petitioner herein is the daughter of late Loknath Saikia. And as per the scheme of the government, the next of the kin of late Loknath Saikia was entitled to the amount of rupees 5 lakhs. However, from a perusal of the affidavit filed by the respondent number 4, it reveals that the respondent authorities have deliberately paid the amount of rupees 5 lakhs to the respondent number 4. On the ground that there was no one to claim on the ground that the writ petitioner did not make any claim. This court have also duly perused the counter affidavit filed by the respondents and finds that the same does not address the issue involved. Under such circumstances, this court directs who pays? The Deputy Commissioner. Huh? Directs the Deputy Commissioner, Nagaon, a District Commissioner Nagaon, who is the respondent number 2 herein, to file an affidavit before the court on such date as has been fixed herein under, as to on what basis the respondent number 4 was paid the said amount. In the said affidavit, it shall also be indicated as to whether the payment was made on the basis of a next of kin certificate produced by the respondent number 4. And if so, the said details may be mentioned in the affidavit to be filed by the respondent number 2. List the matter again on 16th of November 2023. The affidavit be filed by the District Commissioner Nagaon by 9th of November 2023. In the said affidavit, it shall also be mentioned, the Deputy Commissioner, the District Commissioner Nagaon said also mention as to what steps the said authority would take if the amount of ex gratia is paid to a wrong beneficiary.
The list of the monetary record of the monthly stores going to not be clear out. They have mentioned in the monetary affidavit filed by the record number 1. In case
No. Your affidavit of the respond number 1, look at the last paragraph of the respond number 1. Hopeless affidavit. He says that once it is given to some beneficiary, we are not bothered about it. He cannot take a sharp of his responsibility like this.
Can you see the
No, Mr. Hendrik, these people can't shirk off the responsibility. This might be that he on oath has stated that you have on your own given him the money. That is his paragraph number 5, paragraph out there in his affidavit by the respond number 4. And is it what is actually happening? If it is happening, then there is something wrong. Whereas we find a lot of writ petitions being filed out here every day and out that they are not getting the ex gratia. And here is the authority going out there, taking the money and giving it to the authority, some other person. You file your affidavit. No, this can't happen like that. And it needs to be that the deputy commissioner shall pay it from his own pocket, the remaining amount to the petitioner.
Number 10.
Yes, what is this matter?
I did not. For the RD establishment.
Oh, that one.
Yes.
Well, for so many years you have not paid. And what has happened beyond that? What decision have you taken after this 2022, 2012 onwards, na? And thereafter? For what?
For release of the amount for 2017 to 2023, 5 years.
For lease.
For lease.
Okay, then
Then madam, from 2023 to 27, madam, the board has been conveyed to for further hiring of the project, madam.
the hiring, if
And
you,
acquisition process is also going on. Acquisition of the net, madam.
understood. So when are you giving him the money? The sanction has been done, then
The process is going on.
sanction,
Acquisition is 2023.
so done. 11, sanction has been given for the payment.
Okay.
When are you paying?
Madam, pay the amount to the contract.
When? You are defense, you have a lot of money.
Yes, madam.
Hmm. How much is the amount? Oh, that is peanuts for you. They pay it by tomorrow. We can have it on reopening. As the amount paid or not. Huh? Formality, does it take for 7 years for formalities? But you have paid till 2018. 17 you got in, na? From 2018, 1/1/2018 to 31/12/2022.
Yes.
What about 23? Hmm. Hmm. But can you have a compulsory hiring? Is the petitioner willing to give it for hiring thereafter? Willingness certificate is given, Swami? Petitioner has no objection. For further hai? I have already expressed acquisition of land by the army, certified that the land value of this. No, he has a willingness for acquisition, not for not for this type of hiring. So, you cannot go for a compulsory hiring. There cannot be a policy like this to take over like this. His land, he may not like it. You like it? Of keeping 37 acres of land in this manner? Paying for 5 years, you may build in this is where? At Tamulpur, Digholipur, Soya, Bargaon in Assam. So, this is very valuable. You are paying 7,965 per acre per year. My goodness. Where is your senior? Fellow, we have it after vacation and we take the stand and she will make the payment before the next stage. The Learned Counsel, Miss A. Gayan, the Learned Standing Counsel of the respondent of the learned, you are what? Appearing on behalf of the respondent numbers? Appearing on behalf of the respondent number 1, 2, 3, 4, and 1 to 5, submitted that for the period from 1/1/2018 to 31/12/2022, the sanction has already been made for payment of rupees 2,95,406. To the petitioner. The said amount pertains to the hiring charges of 37.088 acres of land for a period of 5 years with effect from 1/1/2018 to 31/12/2022. The Learned Counsel further submits that the process is on and the payment will be made very soon. List the matter again on 14th of November 2023. Very well. On 7th of November 2023, on which date the Learned Counsel appearing for the respondent number 1 to 5 shall ensure that the payment is disbursed to the petitioner. The document so placed by Ms. A. Gael is kept on record and marked with the letter X. Aki says, Om Prakash Gupta. Yes, Mr. Borguya. Shall obtain the necessary as to whether the petitioner. Oh, that one. The originals, do you have that?
But I do not have that. At the time of commission of appeal, I had submitted to the letter.
Mr. Chaudhary. Your matter, they say that 2,95,000. I will ask them to pay that amount before 7th. Then we'll take up whatever happens. Yes, originals. You have it.
So I do not.
Ah,
I had submitted
there the
at
problem
time of-
arises. Yes.
At the time of submission of the bill letter, they asked for me to submit the resolution.
Now, how do you take care of this? Tell me.
Well, how, they said, madam.
Huh?
And four my lord, out of 8 bills. Four my lord, they said.
Four
that,
they have okay, but what about how do you reconstruct the others?
my lord, I'll supply the copy, my lord, there must be having the record then.
They say that they don't have it.
But if they don't have the original piece, they might have somewhere and make entry, my lord. Because, my lord, they have to maintain, my lord, for visual patrol, they need to maintain, my lord. They cannot be like this. Something they have to maintain.
So what do you want now?
Now, my lord, can be disposed of, my lord, I'll approach to the authority, my lord, the whatever application amount that in me, and remaining amount, my lord, I'll give them my copy, whatever I'm holding. Let them construct and consider and pay.
Now, how can I direct them to construct if they can't construct?
Something has to be done.
No. Tell me, how do I direct them to construct if you can unless you prove it that yes, you have given the originals to them. Now, is it the requirement of submitting the originals?
My lord, there,
Where is it?
it's not the law, my lord. At the
Then-
time of submission, Nazareth, my lord, branch asks to bring the original, then only I'll receive the.
Because if I ask them to verify and pay, and you ask him to give documents, they will again refuse. It will be the same, and then one fine morning, you are here before this court with a contempt.
It is pending, my lord, right from 2014.
Understood?
And very small amount, 283 only. That's 63,000. 139 they have had.
Have they denied not receiving the papers?
No.
Have they denied out there
No denial of.
that, no, what is their stand? What happened to those documents? Let's see.
The phone number 3. Well, we'll say in para 4.
That out of the 8 requisition bills claimed by the petitioner, following bills have been referred to the so and so for making payment. Oh, the requisition was made from this end, but the vehicles were placed under the SP so and so. The remaining 4 were as claimed by the builder could not be paid as records of submission of the original bills are not available in the office. Is now asked to submit records of the original as the government payment cannot be made on the photocopies. That is the problem. If you don't have the originals, then how do you pay?
Then come to this, there are 13 months of the evidence.
Yes.
That is 13. Opponent further back to already all of these submitted by the.
Page?
From page 3, there are 13. Opponent further back.
Para 13 is, the reporting backs to state that already all the bills submitted by the petitioner from time to again requisition had been duly paid to him except the bills mentioned in the requisition in para 3. The 4 bills have been referred to so and so for payment and the vehicles were utilized. The remaining 4 bills could not be paid as there is no original record of the bills and the petitioner has been asked to submit the same for making. It is the same thing which has been there in paragraph 4.
And
Then
my lord, respondent number, another respondent, my lord, you also filed an affidavit. Nowhere you deny and matter the item.
no, the fact that they have not admitted that they have received it, the originals.
Each and every bill there is a signature of the concerned person. Concerned person there.
Yeah.
Also to see all the order annexure 1 series is duly issued, my lord. And they have received also, and they have a page 12.
Page 12.
Page 12.
Yes.
Somebody received on,
Why there is no seal, nothing.
it is about their money. Then all the pages they have received.
Huh?
All the pages they have received by the matter.
All were given on same date.
From my lord. 9209, 9220,
No, these are different.
my lord. This is 8309,
Here where? Page 18, no signature,
815 is their number.
no signature,
That's the one.
no signature, 18.
This is their, my lord.
Where?
Page 19.
Huh?
Page 19.
Where? Where is the signature, page 19? No. The wages of the driver is paid by the owner driving. That is what has been written earlier also in all other petitions. Where is the question of receiving? Here again, page 22, no signature.
20 there.
No, 22, no signature. 24, no signature.
Officer himself is there, madam. Whoever.
No, 24 also, no signature. Only signatures are there in some. 4 they have, that is why they are processing, 4 they are not.
Whatever the bill
I can do at best one thing, taking into account the puja vacations are coming. I give direction for them to pay that four bills, and remaining, you submit a representation, show whatever the document to show that you have submitted the original, and if the authorities are satisfied, they can pay. Verify. That is the only.
only time limit.
Understood. If he is asking for so much, so that is the only thing. I can't help you more than that.
I'll accept, but only one time limit to it.
Otherwise, we have to go over.
No, I am not directing. He has to prove that he has submitted the originals to those authorities. And thereupon, upon proof being satisfied, then you verify and pay. That is your lookout. I am putting the ball in your court. Therefore, the instant writ petition has been filed by the petitioner being agreed by the inaction on the part of the respondent authorities in making payment, in not making payment of the bills. In not making payment of 8 numbers of bills, which amounts to rupees 2,83,910 for requisition of the various vehicles of the petitioners from time to time by the respondent authorities, by the concerned respondent authorities. The instant petition was filed in view of the fact that the petitioner had approached the respondent authorities on numerous occasions, and having failed to receive any favorable response, the instant writ petition was filed on 25/7/2014. This court had issued notice on 8/8/2014. The record reveals from a perusal of the affidavit, of a writ petition, it reveals, more particularly from Annexure 1 series, that the said are photocopies of orders of requisition as well as release of the vehicles in question, in respect of which the petitioner claims his entitlement of the amount of rupees 2,83,000. The respondent number 3 had filed an affidavit wherein it has been mentioned that out of the 8 bills reference to which have been made in the writ petition, 4 bills have already been sent to the Superintendent of Police, Dima Hasao District, for making payment by the communication number NCH oblique N dash 923 oblique 2010 dash 11 oblique 2302 dated 23/7/2012, amounting to rupees 1,39,650. It has been also mentioned that in respect to the remaining 4 bills, the submission of the original bills are not available in the office. The petitioner was also asked to submit records of the original bills, as the government cannot make payment on the basis of photocopies only. We are in response number 3. The said communication, which was sent to the Superintendent of Police, Dibahasau District, Haflong, as referred to above, has been enclosed as Annexure 1 to the said affidavit filed by the respondent number 3. It is also seen that the respondent number 4 had also filed an affidavit in opposition. In the said affidavit of opposition, it was in the said affidavit in opposition, more particularly at paragraph number 5, it was mentioned by the respondent number 5 that a vehicle bearing registration numbers AS01-W6036, number 2, AS14B0580, number 3, AS01V5965, and AS01Z4034 were requisitioned oblique hired for convoy oblique escort duty on the routes with Haflong, Diungmuk, Umrangsu Diungmuk, and Umrangsu Dihenge, etc., on different occasions for maintaining law and order. And accordingly, the petitioner had submitted the hire charge bills of the hired vehicles along with the original requisition forms to the Deputy Commissioner, NC Hills Assam, Haflong, time to time for payment and duly received by the Nazir of DC Office, NC Hills, in the year 2008. It was further mentioned that the Deputy Commissioner, NC Hills, forwarded the bills with the photocopy of the requisition forms of the vehicle AS01Z4034 to the office of the Superintendent of Police, Dibahasau, on behalf of the respondent number 4 and 5 on 23/7/2012, and after 4 years by letter number NCH/N-923/2010-11/2302 dated 23/7/2012. The said requisition vehicles have been letter dated so and so. It was mentioned that the said bills could not be entertained by the office of the Deputy Commissioner, Dibahasau, as the requisition vehicles were utilized and released either by the MTO or OC Diungmuk PS. It was further mentioned that the requisition vehicles were utilized by the OCs of the concerned police station for the purpose of convoy and escort duty. The vehicles were requisitioned for the purpose. The record further reveals that the respondent number 3 had also filed an affidavit. The record further reveals that the petitioner had also submitted an affidavit in reply to the affidavit in opposition filed by the respondent number 3. It was mentioned in the said affidavit in reply that the bills bracket Annexure 2 series to the petitions were duly submitted by the petitioner before the authority, as have been admitted by the respondent in his paragraph, and throwing the responsibility from one soldier to another. The respondent number 4 had admitted the same, and the respondent number 3 had filed an affidavit in reply stating inter alia that the bills of the petitioner were duly submitted before the authority, and the respondent authorities cannot refuse to make payment of the amount to which the petitioners were entitled to on the guard, taking the excuse that the bills in originals are not available in the office. It was mentioned that the said respondent can reconstruct the same bills as it has been in their possession all along. And there is an admission of utilizing the vehicles of the petitioner on various occasions for the purpose of maintaining the law and order. In the backdrop of the above pleadings, this court have duly heard the learned counsels for the parties. A perusal of the repetition as well as the affidavit so filed by the respondent number 3 would show that the respondent number 3 have duly admitted that the petitioner is entitled to an amount of rupees 1,39,650 in respect to the bills, in respect to 4 bills. The details which have been mentioned in paragraph 4 of the said affidavit filed by the respondent number 3. However, as regards the remaining 4 bills, it was mentioned that there was no records of submission of the original bills available in the office, for which the petitioner was directed to submit records of the original bills. On the other hand, if this court takes note of the affidavit filed by the respondent number 4, who is the officer in charge of Diung Muk Police Station, he had categorically mentioned that all the vehicles of the petitioners were duly used for escort and convoy duty. The respondent number 4 had also mentioned in paragraph number 5 that the petitioner had submitted the hire charge bills of the hired vehicles along with original requisition forms to the Deputy Commissioner NC Hills, Haflong, time to time for payment. The same paragraph have been sworn as being matters of record by the respondent number 4. And as such, the respondent number 4 would definitely have records on the basis of which the statement was made in paragraph number 5 of his affidavit in opposition. Under such circumstances, this court therefore disposes of the incident writ petition with the following observations and directions. Taking into account, number 1, taking into account that it is an admitted fact that the petitioner is entitled to an amount of rupees 1,39,650, which have been admitted by the respondent number 3 in his affidavit. The said respondent number 3, that the respondent authorities, that is the respondent number authorities, that is it will be the Deputy Commissioner who has to pay. The respondent authorities, that is the Deputy Commissioner cum District Magistrate North Cachar Hills, shall pay the said amount, disburse the said amount to the petitioner within a period of 2 months from the date the certified copy of the instant order is served upon the respondent number 3. Number 2. As regards the remaining 4 bills, taking into account that the respondent number 4 had categorically stated in his affidavit that the bills in originals were duly submitted by the petitioner, all the bills of the petitioner, taking into account that the bills in original along with original requisition forms were submitted to the Deputy Commissioner NC Hills on the basis of records, the respondent number 4, the petitioner is given the liberty to approach the respondent number 4. No, anything. Number 2. As regards the remaining 4 bills of an amount of rupees, amount to minus 283 per 139 minus 2, an amount of rupees. The petitioner is given the liberty to approach the respondent number 3 by placing before the said authority the necessary documents to show that the petitioner is entitled to the said amount of rupees so and so. The respondent number 3, while carrying out the verification, also shall duly take note of, duly inquire with the officer in charge, with the respondent number 4, who is the officer in charge of the police station, as regards the hire charge bills and the original requisition forms which were submitted by the petitioner, as the same is apparent from paragraph number 5 of the affidavit of the respondent number 4, wherein he states that the said statements have been made on the basis of records. It is made clear that if the petitioner is in a position, is able to satisfy the respondent authorities as regards his entitlement, the respondent authorities shall pay the said amount after due verification. The said exercise be completed in respect to the remaining 4 bills within a period of 4 months from the date of, from the period of 3 months from the date a certified copy of the instant order along with the representation is submitted by the petitioner along with the representation and necessary documents are submitted by the petitioner. I think no more, I should not further any more disposal, huh? Because what is happening, we have only 2-3 days. It's very difficult. No other courts are taking up matters for disposal. I think one should not.
Item number 7.
Yes, madam. Huh? Because of his? Yes, what is this case?
Right. 10 other candidates. Now the guidelines provide that even if one of the candidates applies for the corporate fund scheme under the corporate fund scheme, then we cannot give us
Is a stay?
the
If there is a stay, what is the consequence?
status to.
Somebody is running?
No, my lord, we selected, we shortlisted 3 candidates. From then onwards, the candidate.
Who is enjoying? He's enjoying with a stay for 10 years. And you have not filed an application for vacation. And what is the private respondent doing? They are not interested.
Because they were shortlisted. 3 of them were shortlisted. They
Including
were-
the
they were
petitioner.
eligible for it. But,
Including the petitioner was shortlisted. Then the petitioner, how is the petitioner running?
no, she's not running. She's enjoying the status quo.
Are you losing something? No,
Because-
Hmm.
I guess-
not interested.
No, we are interested, now, even though there is no application for vacating the year.
You are not interested. For 9 years, if it has gone, a decade has gone, and you are not interested. Isn't it, madam? 9 years they have been, so they don't want it. You do one thing, we allow the writ petition. What does he want? To select the private respondent, choose basis by giving a go by to suit. He said it like this, go for a fresh one. It's the best way.
Everything has been done by the candidate.
Huh?
Everything has been carried out by the candidate.
So you give a consent, okay, you are going for a fresh one, whatever. Huh? You fight for another 10 years. Rule was issued, that is the reason why, and you have been enjoying. You would never do the matter. For petrol pump at Balajan on NH 31 in Dhubri district is not yet issued. He further submits the evaluation of the applicants were made under the corpus fund and not on the basis of offered infrastructure and financial capacity. He accordingly prays for and is granted 4 weeks time to file response. In view of the above status quo, the allotment of the petrol pumps should be maintained. Nearby, there must have been many more petrol pumps which have come in. It has now become unfeasible. So you may think of not having. We allow it. Giving you the year that you may not like to go ahead.
I cannot say that.
Huh? What?
My lord is allowing the prayer for it. And I can get the instruction.
I'm allowing a prayer for her petition. If I allow her petition, I think she has no objection. Do you have an objection? If I allow your petition, do you have an objection? No, she would never. And further to that, in addition to that, I give the bonus that senior's name would also be put. Then, so we go ahead with that. It's a win-win situation. For you, you want to do business. Respondent number 7, 8, and 9 are not interested. So, you give it, I can't give it, direct you to give it to her. No. He wants another one. Go ahead. The amount of money which you have lost all these 9 years would be no, your hands are tied for what? For giving a consent. No, forget about a consent. We hold it in our favor. It's a win-win for you. Both of you win-win. 2014 matter. What has happened to Mr. Bukash? What has happened to Mr. Bukash? Your senior is Mr. Bukash. What has happened? What illness? Is a stay? We vacate the stay. We'll adjourn it, but vacate the stay. Okay, vacate the stay. Here it has been given till the next date of listing in time order. Yes, we do not extend it. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after the vacations. Ankita, just 1 minute. You can go ahead, Mr. Bharadwaj. No, you can go ahead. There is no interim order any further. Yes. What is this? Yes. Xerox version of what? It shows that the original case record of GR case, which is in relation to merger pending, is here not been received. Directed to take appropriate. Why have I called for the original?
An allegation of tampering of deed. Criminalized case. The lordship sees page number.
No, we don't require the original. Why do we require? We can have a photocopy. Oh, no, original is there.
Page number 36.
These are originals. Seems so, yes, this is the original.
Page number 36.
But this is an original document. No photocopy. Forwarding of the case record of GR case number, photocopy. Nobo Kumar Goswami is hereby undersigned and deputed here. This case is open today on the strength of the order passed by the High Court received on so and so. Here is the order so and so received from the GR as the judiciary was separated from the executive and as the instant case was disposed of prior to the separation of the judiciary, hence immediately call for the said records from him. Also call for the case records. These are various cases. This is done by this court. Upon hearing the learned the observer for deciding the dispute involved with the original report pertaining to which is in relation to Manza case number 1 pending before the court of the Nepal could be required to be produced. To proper chairman. Now, what was the case? This is the original records.
Page number 36 will be forwarded.
Huh?
Running page 36. The lordship sees to forward it.
36. 36.
Name and address of the accused matter. Rohit Nair.
36. Ground of accused. Arrest.
Ground of arrest and below matter. Name and address of the accused matter. Sitting Rohit Nair.
18 years.
Now there is an allegation that there's been some sort of tampering with the, because it doesn't indicate the free flow of a pen. So hence, my lord, if your lordship we can explain, just place the basic foundational facts involved in the on 17/4/2014, an FIR was filed on some unknown person, not even the name of the juvenile figured in the FIR.
Hmm.
Based on the same FIR minor, the minor boy was immediately picked up. He was picked up, he was initially kept in the police lockup, and then he was put in jail with hardened criminals. And finally, he's a minor orphan boy. He's only assistance is of an old grandfather. The grandfather somehow, with the help of some NGO, they filed an application for plea of juvenility, which are actually find at page number 22, my lord,
Or this,
of the writ petition, my lord. So logically, turns to page number 22 of the writ petition. Now, this is before the learned court below. The order dated 3/7/2014.
Hmm.
Now, the minor was not produced on that day.
CR received medical report of UTP Rohit Mek is submitted.
Page number 22 of the writ petition.
No, wait, with the finding that the age of the so and so is estimated to be, with the finding that the age of the said AI is estimated to be below 14 years.
Below.
The court is satisfied with the report and its finding, and hence UTP is being forwarded to the juvenile board. That was then on 10/7/2014.
10/7/2014.
Yes, then,
Now, then my lord, ultimately, my lord, it took around 86 days for the petitioner to get relief from the jail. The petitioner approached this honorable court on 17/11/2014. Notice was issued with the present writ petition. Initially, an affidavit was filed containing a very illogical statement saying that the grandfather gave a signed statement saying that he is above 18.
now what do you want?
The only remedy perhaps is monetary compensation. To that effect, my lord, I have got some case laws for your kind delusion. I can place it for your lordship.
Because on the last occasion, there was some free flow, it was later on written mention. Let us see where, on last occasion, I remember now. Here it is okay. At page 21, it seems to be the same.
Correct.
It seems to be the same.
Same.
There's no difference.
Age,
Huh?
this age, which has been indicated.
Ah,
The allegation is that since there's no free flow of pain, there's some sort of mischief seems to be there. Apparently.
why?
Because he's a boy of 13 years old.
Understood. Is it not possible for this police to make it 18 and write it 18? Yes, they may have, or it may be that while preparing this thing, he must have, okay, let us put this age also. And at that time when he was writing the ground of arrest, he must have been before lunch, and after that it may have been after lunch. Huh? It would have been, and with the after lunch, the pressure on the pen may have been more.
That is quite possible.
Yeah, then,
And then if I may just place before the lordship some of the relevant sections of the Juvenile Justice Act.
yeah, one second.
Quite possible. Section 63.
Or maybe somebody else may also have written.
We don't know.
No, somebody else may also have put the age at that point of time, but would it nullify the thing if it is otherwise done? No. So that is okay. But the fact that, are you saying that prior to sending or remanding the person to the police custody or to the judicial custody, the magistrate ought to have inquired?
Before that, perhaps section 63 makes everything clear.
Of 2015,
But
but this act did not come in then.
is there, 2000 is there.
Yeah. 2000,
2000, because the cause of action occurred in
2000, yes, tell me, para section 15.
63,
order that may be passed regarding when a board is satisfied on inquiry that the juvenile. Huh?
Act of 2000, madam.
Yes, that is one section 15 I am reading.
But section 63 for the moment, we got it. Section 63, madam.
53.
63, madam.
63.
63. Section
Yeah.
63, 2009. Let me just read, madam. In order to enable the police officers who frequently or exclusively deal with juveniles or are primarily engaged in the prevention of juvenile crime or handling juveniles or children under this act to perform their functions more efficiently, they shall be specially instructed and trained. And subsection 2 says, in every police station, madam, at least one officer with aptitude and appropriate training and orientation will be designated as the juvenile or child welfare officer who will handle the juvenile or the child in coordination with the police. So there is a statutory mandate that in every police station, madam, there has to be one designated juvenile officer.
Mm.
And
No, that may not have been mandated. Then what happens?
so the moment, if they cannot distinguish between a 13-year-old and a major,
Hmm,
that means there is a serious lapse on the part of the authorities.
hmm.
They cannot and they
No,
cannot.
no. When did grandfather file that application?
Grandfather filed the application, but not on 3/7.
And on 10/7, this has been come.
10/7, 3/7 did not produce the minor. 3/7 minor application was filed. The honorable court on the very next day asked for the medical report. They did not give the medical report. The matter came up on 9th. The 9th, the learned court below immediately asked for the report. On the 10th, the report was placed and immediately he was released on 10th. So no fault can be
So
attributed.
prior to that, did you approach the police at any point of time?
The allegation, the contention is that they have approached and they will not, entertain. So
How have you approached?
because
Why didn't you approach? If you have approached there, why not the police? Why not the magistrate at that point of time? Why you took on, because here now you are asking for compensation. Yes, it may be. There has been lapse, but what did the police has to be put to notice. Have you put the police to notice at any other point of time earlier?
if you lordship kindly see,
Because it is, yes, on the face of it, a 13-year-old, one can very well say that, yes, they couldn't have been as the 18-year-old or whatever, maybe it can't be done. But the fact that he may have been a grown person or looks to some 13 or 14-year-old, looks nowadays, if you see a lot of kids out there, 14-year-old looks like an 18-year-old.
but that is why the government conducts a sensitization program of these officers pilot from time to time. And lots of funds are used. And that is why all these special programs are made. That is why that is what the purpose of the act is. Section 6.
Now, what has happened out there? What has happened to this GR case?
Here case, the other accused has, it seems, have accepted his plea. And
Now, matter has finished.
that is,
Now, do we require to keep this file? No.
I think there is no requirement.
We do one thing, we return the file. And we'll have it after vacations now, because there we will look into as regards the other aspects. Huh?
What I have found.
This court had pursuant to the orders passed by this court on 8/8/2023 and 14/9/2023, the LCR of GR case number 313/2014 have been placed before this court. These are original documents.
Page number 33.
No, these are all original records.
The forwarding seems to be Xerox.
Now, forwarding is says here, Xerox, but these are all original documents. See, these are all original.
Some of
Can-
them
You have an X-ray, can it be original? The photocopy.
forwarding seems to be
Here, this is the form supervisor's order of that.
page 36.
So page 91 here. In the preliminary detained mayor, that a juvenile along with the copies of the order had a bond executed by him. These are Iman order passed by so and so Manja police in connection with juvenile Rohit Meg. So and so. Full stop. Full stop. Upon perusal of the materials on record, this court is of the opinion that the said records be remitted back to the Chief Judicial Magistrate Karbi Anglong, so that the same may be remitted. However, the registry is directed to retain a photocopy of the said records, as the same may further be required at the time of final disposal of the petition. To list the matter again on when? 21st. I'm about 40 in 21st. Huh? We have it in December. 12th. 12th of December. Mr. Agarwal may be a bit free there. 12th of December.
In fact, I looked up some of the Supreme Court judgments that say that perhaps the only practicable mode of redress is by award of compensation.
Understood, but the question of award of compensation, it could go ahead. A borrow territory, no, yes, mode of compensation. The moment the question of mode of compensation comes, the question of mitigation also comes. Mitigation means, did you take any steps for that? If you have not taken the step, then because you are claiming on constitutional thought. We'll go by DK Basu or Upahar judgment. These are the two judgments on that. And there are many others. But the thing is, whether there was any possible for the police authorities to know that yes, this person was a 14-year-old, 13-year-old boy.
They were told several times that again.
That is what you could have very well written a letter to anybody prior to that. Why haven't you written?
They have to meet the.
You could have written a letter, kept it on record. Better do that, then it would have been more better.
Then after that, don't you think he went to the magistrate?
They most probably didn't get hold of Mr. A.R. Agarwal, the multilingual Mr. A.R. Agarwal, who knows all the languages of these places.